Thank you, everybody, for joining us for another edition of Condo Insider. I have with me today Forest Jenkins, who is with the law firm of Goodsill Anderson Quinn Stifle. And our topic that we're going to talk about today is really like latches and estoppels related to like house rule violations. And also what happens when the board doesn't properly maintain those house rules, because I've been hearing a lot like they get lax on it for a while and then all of a sudden they get up in arms and they want to start enforcing it again. You know, it creates another can of worms. It can lead into some major legal costs for the board in trying to get that back into shape again. So one of the things that we're going to use it as an example is a window AC. So we know a lot of buildings will allow for window ACs, but they also have certain requirements as to how it has to be installed. And one of the reasons for that is they need to protect the building ultimately. And so with the window ACs, you have that coolant that drips out from the box, you know, and you can't, you don't want it to drip because number one, it'll kill the plants if it drips into a planter. If it's like in a lanai area, or if it will drip against the building, that's going to ruin the siding, or even if it's a concrete, so whatever the finish is, it's going to ruin that, you know, because that stuff, if it can kill a plant, can you imagine how caustic that thing is, right? So they want to protect the building. So I know some buildings have required that it be either plugged or there's a drain thing installed, a PVC that needs to be flowing away from the building. And I know some have installed like a PVC thing along the length of like the lanais or wherever it is. They have to all connect in, and then it kind of drains it away from the building. So they have different requirements. Some have trims that has to be done. Like I've seen some AC, they're encased in like a lattice kind of a box because you can see it, the lattice from the outside. And also one of the other big issues is the rust, the eventual rust that happens on that metal. So Forrest explains to us how, you know, so they have these house rules. I know some of them prior to installation, the board has to approve it, and they'll also give them a copy of all the requirements for that installation. So guide us through like what happens when the board doesn't equally maintain that house rule, like every month or even every day, because rust can appear, you know, somebody moved in and they put one in not knowing that those are the rules. So what happens when something house rule isn't enforced regularly the way it's supposed to?
Thanks, Raylene. So yeah, that's obviously a hot topic. What happens when there's a property manager who's not enforcing house rules, or a resident manager, or just the association for that matter? And what's the association looking at when they want to start actually enforcing these rules? And, you know, it presents an issue because anytime, you know, you go through the enforcement process, you're looking to ultimately get compliance, but if they don't, you're going to have to file a lawsuit. And that's going to be a breach of contract lawsuit and a suit for an injunction as well. And, you know, the non-enforcement of these, you know, house rules brings up a couple different doctrines. There's waiver, estoppel, and latches that the board should be have knowledge of and consider. I'll talk about those really quick. Waiver is defined as an intentional relinquishment of a known right, a voluntary relinquishment of rights, or basically the refusal or, you know, failure to use a right over time. And, you know, essentially the board sets itself up for the defensive waiver if it kind of rests on its laurels and never enforces this. There's also estoppel. There's equitable estoppel. That's whereby one's words or conduct, one willfully causes another to believe the existence of a certain state of things and actually induces another to alter their position. So that would be if the board actually, you know, says something or says, hey, we're not going to enforce this, and leads to homeowners actually, you know, breaking the house rules based on those statements. There's also quasi-estoppel, which precludes a party from asserting to another's disadvantage a right inconsistent with a position previously taken by him. And this principle basically says that a board can't blow hot and cold. You can't say, oh, we're not going to enforce this. And then suddenly with a new property manager, try to enforce a house rule. So waiver, it's more or less just failure to ever enforce. Estoppel is more of an affirmative statement to lead somebody to believe that the house rules aren't going to be enforced. And when we talk about these doctrines, they're affirmative defenses. So say you sue an owner. Essentially, his attorney is going to come on, he's going to answer the complaint and assert these affirmative defenses. And ultimately, he's going to look to file a motion for summary judgment and say, in the circuit court, and say, Judge, they've never enforced these rules. They can't now. They've effectively been waived, and they're not enforceable against us. And there's actually been cases where circuit court judges haven't enforced it based on the prior conduct of the board.
So when you're talking about that waiver, so it's like a homeowner been there for 5 years. AC's she took over the unit. AC was already in there, but it's showing the signs of wear. Like the rust. And then it's not attached to the drain, and she uses it more religiously than the previous people. And then she, and then it makes there's a comment from another owner saying, hey, you're not supposed to have it that way. It's supposed to be, all the rust. You got to make sure you fix the rust. And so they approach the resident manager, say, hey, I didn't know about this. It was already installed, and the resident manager says, oh, don't worry about it. So I think that's one of the biggest red flags is when you have that comment given back to the owner. So that creates, it opens up that can of worms. And I think the boards need to be really diligent that it's part of their employment agreement with the resident manager of his duty of making sure that he enforces the house rules equally to everybody. Because he is essentially, that person is essentially, I want to say the enforcer, but he's got to make sure that everybody complies with the house rules the same as everybody else. New owner or old owner, doesn't matter. They still have to comply because they entered into that contract when they purchased the unit, right?
Absolutely. Yeah. And it's critical that your property managers don't make affirmative statements like that, because that's pulling it right into the ground of equitable estoppel. There's going to be a declaration saying, hey, the property manager said this. And if they prove that it actually happened, then the circuit court's just going to throw your case out. You may have to pay it, under 514B, you would have to pay attorney's fees. So now you're in a case where you've gotten to a lawsuit, you're paying tens of thousands of dollars, maybe in fees, and you can't enforce your house rules. And then, it just becomes a mess. So that's a mitigation measure, is just tell your property managers, hey, we enforce these by the book consistently across the board, no exceptions, and you can kind of head that off at the pass.
And I don't think some people realize that the water that leaks out is very caustic. Because I remember when I had a window AC installed and I saw the water dripping and I was teasing the guy. I go, should I put a plant there? He goes, I wouldn't. And then I know another person I was talking to, she had a portable AC, and those you have a reservoir where the water collects in and you have to dump it every once in a while. She goes, she was dumping it into her planter on her lanai. And then she realized that that's what caused the plant to die. So I was like, oh, that's that bad. But it also damages the concrete. Even if you may have waterproofing, gray coating stuff on it, it's so caustic that it's going to eat through that. Now you've created, or potentially have created, what I call a man-made spalling, because that water purposely dripped, and now you've created a hole in the concrete. Now it's spreading out to the rebar, because concrete is very porous. It absorbs water. So that's why, that's part of the reason why homeowners have to be aware, condo owners, that there's the reasons why for certain installation requirements, which is to protect the building. And when you're protecting the building, you're also protecting the cost, the maintenance costs that's tied to our maintenance fees. So everybody has to be cognizant that, it's not because the board wants to be Mr. and Mrs. Meanie. They're trying to preserve the integrity of the building to prevent unnecessary repairs, or repairs that might be sooner than what it should have lasted before, because even if it's painted, that stuff will deteriorate. it'll seep through the paint and hit into the concrete of the building, or even the external the siding, the wood siding. And I mean, it'll definitely damage vinyl siding as well. So homeowners should be aware that it's not because the boards are trying to be, what was the one word someone said, dictatorish. They're not trying to be that way, but a lot of it has to deal with trying to maintain and preserve the money that comes out of our pocket for repairs. And we all know that's only going up, and that's also one of the big issues with insurance policies, is the deferred maintenance that their insurance companies are seeing on the buildings. Because you have no idea if an insurance company came to visit the property, they can just walk around the exterior perimeter and take a look to see the condition of the exterior. They don't always have to go walking around on the inside, but it's the exterior that's going to be, to me, the major red flags that's going to be more observed.
It's it's important, obviously, that the board takes action to preserve the property. And one other thing that they should be aware of, another doctrine, is the doctrine of latches too, because that provides that essentially if you just sit and wait and wait and wait, eventually you get to a point where the court's going to say, hey, this is unenforceable. You haven't enforced it in so long that you can't enforce it now. And for latches, there has to be unreasonable delay, and the defendant would have to prove that they've been prejudiced. But courts have enforced that in condominium cases, especially when there's witnesses who have passed away or records that haven't been kept because they switched property managers. So, it's important that they realize that being diligent with the house rules is critical, because you're looking at all these doctrines as, kind of the handbook of defenses that owners are going to raise. So diligence, I think, is the most important thing to preserve the property.
Yeah, when it comes to those AC boxes, someone goes, and it was rust. I mean, it was rusted. I mean, like, you can see the rust growing. And rust grows. It's like cancer. Some people call it the cancer of metal, And so there was one person that was telling me, yeah, there was a complaint because this one AC box was really, I mean, holes in the metal. But yet the owner is like, well, it's only been there for a little while. We're like, not with that condition of rust, I mean, it's severe. It's not just starting, it's severe. So it's been there for a few years, So sometimes I tell people, I go, you got to be upfront. Just don't lie, because you're just making it worse. You're only making it worse for yourself. They know ultimately when they installed it, it was due for a new one, or at least to repair that the rust on the box, which can be repaired, but it's not a forever fix. It's only a temporary fix. So what would be your best advice to condo boards and their site people, resident manager, GM, or just a site off-site person, when it comes to enforcing these house rules, the best practices from an attorney standpoint?
Best practices are, meet with your property manager, no matter where you're starting. If you think you're behind the eight ball, you've let some stuff go, the sooner you act, the better, because all the time is ticking away and the optics of it look worse and worse. So just meet with your property manager, meet as a board and say, look, we're going to have to enforce this stuff. We have to enforce it uniformly, and just start taking, diligent actions to enforce your house rules, because you just want to avoid these defenses. And, you can't, if it's a situation with AC and you've let some go, you have to start enforcing at some point. And honestly, there could be arguments, if you have to sue the owner, that come up. But the longer you delay, the more you subject yourself to these defenses. So at some point, just meeting, saying we're going to be active, we're going to enforce our house rules. And then also across the board, there can't be, we're going to enforce it this way over here, but this way here. It has to be consistent, because selective enforcement is going to be another textbook defense that they bring up. But you avoid all these issues by just being diligent and being professional and enforcing the rules across the board.
So if they haven't had a lax enforcement prior, now they have a new resident manager or site manager, and the board really wants to get caught up onto that. Would it be prudent for the board to actually send out a notice to everybody effect, like a 60-day notice effective on this date. We've noticed that we have AC boxes that are rusting or need to be replaced, whatever the issue is. And we're giving 60 days notice that effective on this date, we will start enforcing this house rule. Would that be something to start off with?
It would be good just to provide some notice. Obviously, the association should talk to their own counsel before they do
Right.
that, but it would be good and give some time to comply. Optically, it appears reasonable. I would caution in that letter, never say we haven't enforced in the past
Right.
or we're changing, because you don't want to have an admission to one of these defenses, because that's going to be exhibit number one. They admitted they hadn't enforced it. So yeah, be careful with that letter. Talk to your counsel, but giving some time for compliance as opposed to just, enforcing after you haven't for so long will look better if it has to go to court. But again, I would caution about, no historical background or admissions that, hey, we haven't enforced this in the past, because then you're kind of just setting yourself up
Right.
for a defense.
Yeah, good points. Yeah, I kind of would tell people, say, you might want to do it like in the spring, because that's the best opportunity to buy a new AC. Home Depot, you walk in the front, it's just loaded with all those ACs, So kind of like time it where it'd be easy to find a replacement, which would be send it out in the spring so that, by the time they get to it, it's like, it's easily available to get. Otherwise, you're Best Buy and you're ordering it online, then it gets delivered. It's hard to order stuff through Home Depot, especially an AC would be really hard. And I've heard
It's a good point. I mean, when you're dealing with some of these cases and you're switching gears to enforcement, whatever you can do to minimize the impact on the owners and kind of get people towards compliance and then active enforcement, because once you get to a point where you've kind of cleared those old cases and you're actively enforcing, then you're all good. Then you're in the clear.
Yeah, because even the boxes too, and this is my biggest fear when you're in a building. And when I lived in a condo, I never wanted the AC because I have this fear that it's gonna fall out the window. So I think when I finally did one, I told the guy, can you put it a little bit more toward the inside? Because at least it's not so much weight on the outside. I just really have this phobia that it's gonna fall out the window. But people have to understand when that casing starts to rust really bad, there's not that additional support to hold the main part of it in the unit. It potentially could fall out off the box if that box is kind of like all rusted to the point that there's no tensile strength in that metal to hold the pieces together. I think some people don't really understand that part of it. If they've never been involved in installation, because I know with my big one that we did, it's a 221, so it's big. I mean, that required 2 people just to put it in, and the amount of screws and boards they put on the inside, I'm like, okay, I feel comfortable. I know it's not going to fall out.
And you raised a good point too, because there's so many things that can stem off, enforcing this. And one of them, I mean, is if there's hazards, for all kinds of different things, the board really has an interest in actively maintaining the unit, and doing things that are going to keep the unit safe. So it's another reason to just, be proactive and enforce the rules.
Yeah, because they brought in a professional to write up the specs for the installation. Especially the sliding windows. You don't really have, especially you have the big sliding windows, you don't really have a bracket. You have to install a bracket, create that bracket to prevent it from falling outwards. So there's a method to the madness of creating the guidelines of installation and why they have that guidelines, and the whole purpose is of, so it does not harm anybody or accidentally fall out. I always feel like in the high-rise buildings where they're all glass and you see a boarded up window, and I'm like, so how did it break? Did it break
Right.
and go on the outside? And like, what happened to the people down below?
Mhm.
So it's kind of spooky when you're talking about glass, that potential for that. And plus the gravity falling down, right? I mean, it's going to do major damage if it falls out of that window, or out of its place. Okay, this is great. So I really appreciate this from you. What about the word that I always heard I've been a condo owner since the 1990s. So I remember the word precedents.
Right.
So what do they mean by that?
Well, precedents in the legal sense is case law. And that's basically just, cases evolve. It goes to the ICA, the Hawaii Supreme Court rules. And, these doctrines evolve with cases. One example is Latches in 2016 went from an equitable remedy to now a legal remedy as well. So you can assert it in breach of contract. So precedents in the legal sense is, how cases kind of evolve. But precedents in the sense of kind of what the board does is they set a precedence of their enforcement, and it's looking at the history of board actions and looking at, enforcement or non-enforcement. And if you set a precedence as a board or maybe a former board of, hey, we're going to let this go or we're not going to do this, and then you switch gears, then you open the door to these defenses. And same thing if a property manager or resident manager is saying, oh, that's okay, or don't worry about that, you're setting a precedence that these equitable estoppel remedies could come. So, it's looking at the history of the board action, and there's always a spotlight on it. So,
yeah, well, you never did it before. Now you're doing it now. And well, you always let that guy get away with it. That kind of argument that you hear with owners and board members and stuff like that. Okay, yeah, okay.
Yeah, so and the sooner you right the ship, the better. I know it's going to be awkward maybe with a few owners and whatnot, but the sooner you kind of correct the path, the better, to be honest.
Yeah, and I think sometimes when you explain to them why you have it, an installation a certain way, the precautions, the maintenance, it could damage the building. I think, and especially if you put it into a dollar number that we all pay through our maintenance fees, I think that's going to be very powerful for them to understand.
Yeah.
Especially in today's world with rising maintenance fees,
Oh yeah, and insurance rates.
Yeah. And I'm sure, if AC fell out of a window, and they claim an insurance, that's another can of worms, right?
Mm-hmm.
So, okay. So thank you, Forrest, for explaining to us from the legal standpoint about house rule enforcement, latches and estoppel and precedents. So we really want boards, and the one thing I like about Condo Insider is because if you're a new board member, you can always refer to these. You don't have to wait for a training on it or anything. And we do them so they're only 20 minutes or less. Some of them are a little bit longer, but like I told someone, I said, I can't sit still for longer than 20 minutes. I go, then I got to put it on pause and go do something else. But we try to make it so that it's within we get as much information within that time period. So you get the gist of it so that you can become a very well-informed board member, and a positive contribution to your condo community as well. So I appreciate you joining me on Condo Insider, and also being part of. I'm welcoming Goodsill Anderson as part of our attorneys that we use for speakers, because that's been a welcoming thing too. Is insights from different condo attorneys rather than using the same ones all the time. So that's really been very, very good responses from our audience too, especially even after the seminars. They're very thankful that we've got some new faces that they see at our seminars.
Yeah, and thanks so much for asking me too. It's I appreciate the opportunity to come and talk about these things.
Okay, great. Okay, so thank you everybody for joining us, and we hope to see you, or you click on another version or another episode of Condo Insider that we have on our YouTube channel. Thank you.
Thanks, Raylene.
Thanks, Forrest.